All right, the next one was the motion to dismiss any and all charges.
This is based on, as I said, a plethora of issues, including constitutional violations, which I'm not going to get into. I'm sure you understand what is written here. As in being the only member of society in the room and in the hallways, I don't see how I could be the victim and the perpetrator of a crime. It makes no sense that the number one victim named was society, and seeing that I was the only member of society, not a government worker, not a police officer, not a commissioner who's getting paid to be in that room, they cannot be considered a member of society. As I wrote here in Black's Law Dictionary, the definition of society, and that's not government workers. Second, as you can see in my circuit court opinions on following and asking public officials questions of public interest in public spaces is not a violation or a disruption. It's being the press, asking a lieutenant or a deputy where or what happened. That cannot be deemed as an interruption or interference. It's my First Amendment right as the press to investigate, ask questions of public officials in the course of doing their business. That cannot be deemed a violation of the law. Now, you can interpret whichever way you want, Your Honor. The Fifth Amendment violation being the victim and the perpetrator at the same time. As far as I know, the only crime that can be committed in is suicide, I would imagine. You can't be a victim and a perpetrator of a crime at the same time. It puts you in, especially as a pro se individual. I don't see how I could cross-examine myself or cross-examine the state, because they're representing me as the victim, and I'm defending myself as the perpetrator. It's just something that I found interesting, and I couldn't juxtapose it in any way. So I hope that you could clarify that. Another important thing is Ms. Poling did send me a motion, a response to my motion, challenging these charges. And do you have this, Your Honor? Yes. Okay. On number 4, I'm only going to read this portion. And this is facts that the prosecutor and the state have brought into this case up to this point. So I feel that I can have an opportunity to rebut these facts. That the defendant was afforded an opportunity to cease his disruptive conduct. He persisted until additional law enforcement was called to respond to the meeting. There was no disruption whenever the deputies showed up. I have pictures right here.
Okay, but we're not doing that today.
Okay, well, it was 1:30 whenever the deputies showed up.
Okay, well,
Okay, but I'm responding to her foundation of the...
I'm sorry.
Yeah.
I don't mean to interrupt, but if he's trying to use photographs or information that he's not attached to his motion, I would ask for a copy of that.
Here's a copy right here. You could have these.
okay.
She brought up the foundation here with the facts that the sheriffs were called. So I have a right to rebut that, Your Honor, in this preliminary trial. She opened it, not me. I'm not bringing this on my own. She opened it with saying facts of the case. In this, you say that your words can be used. Well, her words are going to be used right now. And the problem is the police were called even before the meeting started. So how can I have been disruptive? That's impossible.
Okay.
The meeting started at 1:30. They showed up at 1:28 in the afternoon. How can I have been disruptive? How can the phone call been made if I was disruptive when I never spoke a word? I'll end it with that, Your Honor, and that's led to bringing it in her own statement.
There is no question that the state is trying to bring in any argument that Mr. Bollin's conduct during the public portion of the meeting was improper. This is a public meeting. It is open to the public. Any individual, whether they be a member of the community, be a member of county government, employees, business owners, anybody is entitled to attend these county commission meetings. That's why they're required to publish the time, the date of these meetings. That is not what this charge is for. And I think that's wherein lies part of the issue with the confusion, I believe, with Mr. Boland's arguments is he's trying to make reference to amendment violations for him being present at the meeting, for him speaking at the meeting. And my understanding of the complaint and the charges in this case is not what is at issue here, which is why I put that in my motion. And if the court will look at number 6, that's what I put in my motion. That the violation that he was charged with was for what his conduct was after the meeting.
Do you know where Hacker is?
I'm sorry, I didn't hear you.
So the fact that law enforcement was present for part of the meeting is not what is subject to this complaint. It was at the point that he was done with his public speaking, and he continued to disrupt the meeting after that while he was in the hallway with his voice, with his conduct.
Do you know where Hacker is?
I'm sorry.
Do you know where Hacker is?
And that's what's at issue. So at no point was he restricted with his communication and with his presence while in the meeting, based upon what I have provided as discovery in this case. It's the conduct that occurred that resulted in him asking to leave and in the hallway. And so that, I think, is where we need to distinguish between his arguments and what he set forth in writing and what he's trying to articulate. So it appears what his response, which wasn't in writing for me to respond to, but if I'm interpreting what you've just said, some of your issues is because these people were there before. I don't think there's anything that indicated that Mr. Boland disrupted the meeting at 1:28. I think the issue is after the public comment portion. And so that would be my position. If I'm inaccurate based upon the law enforcement, obviously that's what the police report is for, that's what the narrative is for, and that's ultimately what the testimony would be for with the witnesses. But from my review of the report and my understanding, the conduct that is at issue is after his public portion was finished, he interrupted and disrupted the remainder of the meeting. So,
I'm going to ask you to either shut up or leave.
Can I respond to that, Your Honor?
Yes, sir.
They were called for a disturbance, correct? Yes. What disturbance? What they did was they predetermined that I was going to commit a crime. That's why they were there. And her response and what she is being told by law enforcement is that they were called only after the disturbance. She says it right here. When that is not true, they were called prior to. So to me, it says here the defendant was afforded the opportunity. He persisted until he persisted, meaning I continued. I started, which I never started. Persist, you have to start something in order to persist in it. I never started. So how was I persisting for law enforcement to be called prior to me even going out into the hallway? This is my inflection of my voice, Your Honor. This is the way I speak.
Understand, sir.
but that's also in the state's position. He has to conduct himself in a manner, just like in this courtroom, just like in a meeting, in which he can maintain it in a level that he needs to.
I am.
I understand that that's how he talks, but that's also can be why you get in trouble when you don't follow the rules.
All right.
So,
So I'm gonna
Inflection of speech cannot be deemed a crime. It's the level of violence that you intend with your speech in order to have committed a crime.
Okay,
Yes, ma'am.
we're finished.
Yes.
I'm not going to dismiss the case and all the charges. I'm not going to bring it.
I'm sorry.